6 families refused to accept the first answer. They asked prosecutors to look again, to reopen the files, to reconsider the medical evidence, the witness statements, and every detail collected by detectives. They wanted to know whether Lucy Letby should be taken back to court and prosecuted for 6 more alleged attempted murders involving 6 babies. The cases were reviewed by a prosecutor who had not made the original decisions. The evidence was examined again. The legal test was applied again. And on August 5, 2026, the families received the final answer. No new charges. The previous decisions would remain in place. Lucy Letby would not face another trial over those 6 allegations. But his announcement did not answer every question. In some ways, it created even more. How can 6 families ask for a complete review of allegations involving their children only for prosecutors to reach the same conclusion? Does the decision mean that nothing happened to those babies? Does it mean that Lucy Letby has been cleared? Does it affect the convictions for which she is already serving 15 whole life orders? And why, after another extensive examination of the evidence, did prosecutors decide that these 6 cases could not be placed before a jury? To understand the latest decision, it is important to separate what has been legally proven from what remains alleged. Lucy Letby is a former neonatal nurse who worked at the Countess of Chester Hospital. She became the subject of one of the largest and most controversial criminal investigations in modern British history. Following 2 criminal trials, juries convicted her of murdering 7 babies and attempting to murder 7 others. She received 15 whole life orders. That means she is expected to spend the rest of her life in prison. Those convictions remain in force. They have not been overturned. Her sentences have not been reduced. And the latest announcement does not change any of the verdicts already returned against her. Lucy Letby continues to maintain that she is innocent. Her legal representatives continue to challenge the safety of her convictions. But unless those convictions are overturned by a court, they remain legally valid. The latest decision concerns different allegations. These were not charges from her previous trials. They arose from a separate investigation into incidents involving other babies. After the original criminal proceedings, Cheshire Police continued examining medical events connected to Lucy Letby's time at the Countess of Chester Hospital. Detectives also investigated incidents at Liverpool Women's Hospital, where she had previously completed periods of training. The investigation involved large quantities of medical information. Detectives examined patient records, staff movements, witness statements, and expert opinion. They looked at deaths. They looked at collapses where babies survived. And they asked whether any of those incidents could support additional criminal charges. In July of 2025, police sent a new file to the Crown Prosecution Service. The file concerned possible offences involving 9 babies. Prosecutors were asked to consider 11 possible charges. For 2 babies who died, prosecutors considered whether the evidence could support allegations of murder and attempted murder. For 7 babies who survived, prosecutors considered possible attempted murder charges. Some of the incidents were connected to the Countess of Chester Hospital. Others were connected to Liverpool Women's Hospital. Each possible charge had to be examined separately. That distinction is crucial. A person who has already been convicted of serious crimes does not automatically become legally responsible for every other allegation made against them. The prosecution must still prove every new offense using reliable and admissible evidence. Previous convictions can form part of the legal context, but they cannot replace proof. The question was not whether prosecutors found the allegations concerning. The question was whether the evidence created a realistic prospect of conviction. That is a specific legal test. Before prosecutors can charge someone, they must believe that an objective and properly directed jury is more likely than not to convict after hearing all the available evidence. Prosecutors must examine the strength of the witnesses. They must examine whether expert conclusions can survive detailed questioning in court. They must identify weaknesses in the evidence. They must consider innocent explanations. They must consider what the defense could say. And they must decide whether the case remains strong after every reasonable challenge has been taken into account. Suspicion is not enough. A troubling medical event is not enough. The fact that an incident remains unexplained is not enough. Even a strong belief that something criminal happened is not enough unless the available evidence can support the allegation in court. In January of 2026, the Crown Prosecution Service announced its first decision. No additional charges would be authorized. Prosecutors concluded that the evidential test had not been met in any of the 11 possible charges involving the 9 babies. That announcement was significant. But it did not mean that prosecutors had proved nothing happened. It did not establish the exact cause of every collapse. It did not provide every family with a complete explanation of what happened to their child. It meant only that the available evidence was not strong enough to justify a new criminal prosecution. For some of the families, that conclusion was impossible to accept without another review. They use a formal process known as the victim's right to review. This process allows victims or certain qualifying family members to challenge a decision not to prosecute. It does not automatically create a new trial. It does not guarantee that charges will be brought. Instead, it requires the decision to be reconsidered by a prosecutor who was not responsible for the original conclusion. The reviewer examines whether the first decision correctly applied the law and the available evidence. If the reviewer believes the original decision was wrong, it can be overturned. If the reviewer agrees that the evidential test was not met, the original decision remains in place. 6 families requested reviews. Their request concerned 6 alleged attempted murders involving 6 babies. The review did not cover all 11 possible charges from the police file. It focused on those 6 attempted murder allegations. An independent prosecutor then began another examination of the material. According to the Crown Prosecution Service, the review was extensive. The prosecutor reconsidered the evidence supporting each allegation. That included medical material, witness evidence, and information gathered during the police investigation. The reviewer had to ask whether the evidence was capable of proving that a deliberate attempt had been made to kill each baby. It was not enough to prove that a baby had suffered a serious collapse. It was not enough to show that Lucy Letby had been present. The evidence would need to support the allegation that she deliberately caused harm and intended to kill. Intent is one of the most difficult elements to prove in an attempted murder case. Prosecutors must demonstrate more than dangerous behavior. They must establish an intention to cause death. In a medical environment where babies can become critically ill for many reasons, that legal burden becomes even more complex. Every collapse must be examined against the baby's medical condition. Prosecutors must consider whether the deterioration could have happened naturally. They must consider whether treatment failures, infection, medication, equipment problems, or other medical explanations could have played a role. They must also consider whether expert witnesses agree. If the experts disagree about the cause of a collapse, that disagreement can create reasonable doubt. If the evidence cannot establish how harm was caused, proving who caused it becomes even harder. And if prosecutors cannot establish deliberate harm, they cannot prove attempted murder. The independent prosecutor reviewed the cases with all of those issues in mind. Then came the final decision. The original conclusions were upheld. No new charges would be authorized in the 6 alleged attempted murder cases. The Crown Prosecution Service said it had written to the families explaining the outcome. It also offered to meet them and answer questions about the review. For those families, the result closed one legal route. There will be no criminal trial concerning these 6 allegations. There will be no prosecution opening statement describing what prosecutors believe happened. There will be no medical experts giving evidence before a jury. There will be no defense team challenging the allegations in open court. And there will be no verdict of guilty or not guilty. That absence matters. A decision not to charge is not the same as an acquittal. An acquittal occurs when a person is prosecuted and found not guilty. In these 6 cases, prosecutors decided that the evidence was not strong enough for the allegations to reach a trial. The allegations therefore remain unproven. They cannot be described as additional crimes committed by Lucy Letby. The 6 babies cannot be legally added to the number of victims established through her existing convictions. The correct wording is that prosecutors considered allegations of attempted murder but concluded that the evidential test for new charges had not been met. Nothing more. Nothing less. The decision also does not prove that Lucy Letby is innocent of the offences for which she has already been convicted. The existing convictions came from separate charges, separate evidence and decisions made by juries after lengthy criminal trials. Those convictions remain active. The latest review does not remove them. It does not cancel the 15 whole life orders. It does not result in Lucy Letby leaving prison. It does not order a retrial. And it does not require the appeal courts to reconsider the previous verdicts. This is where the public discussion can become misleading. Some people will use the decision to claim that the entire case against Lucy Letby has collapsed. That statement is false. The Crown Prosecution Service did not reconsider the convictions from her previous trials. It considered separate allegations that had never resulted in charges. Other people will argue that, because Lucy Letby has already been convicted, prosecutors should automatically have charged her in every additional case. That would also be wrong. The justice system cannot prosecute someone simply because the person has been convicted before. Every new allegation must be supported by evidence capable of proving that specific offense. The legal test does not disappear because the suspect is already serving life sentences. In fact, the seriousness of the allegations makes careful scrutiny even more important. Attempted murder is one of the gravest offenses in criminal law. Taking such a case to court without sufficient evidence would be unfair to the accused, unfair to the families, and damaging to public confidence in the justice system. A failed prosecution could leave families with even more questions. It could also create the false impression that a not guilty verdict provides a medical explanation for what happened, when a criminal court only decides whether guilt has been proven beyond reasonable doubt. The latest announcement exists inside a much larger legal and public controversy. Lucy Letby's legal representatives have submitted an application to the Criminal Cases Review Commission. The Commission is examining whether there is new evidence or a new legal argument that creates a real possibility that the convictions would not be upheld by the Court of Appeal. That review concerns the convictions already obtained. It is separate from the Crown Prosecution Service decision not to bring new charges. The Criminal Cases Review Commission does not decide whether Lucy Letby is guilty or innocent. Its role is to decide whether the case should be returned to an appeal court. If the Commission does not refer the case, the convictions remain in place. If it does refer the case, the Court of Appeal would then decide whether the convictions are safe. No referral automatically cancels a conviction. And no review means that an appeal will succeed. There's also a public inquiry examining events at the Countess of Chester Hospital. The inquiry is considering how concerns were raised, how hospital leaders responded, and whether opportunities to protect babies were missed. It is also examining the experiences of the affected families and the actions of medical staff and administrators. But the public inquiry is not a criminal court. It cannot convict Lucy Letby. It cannot acquit her, and it cannot overturn the jury verdicts. These separate processes are often discussed together, but they answer different questions. The public inquiry examines the hospital and the handling of concerns. The Criminal Cases Review Commission examines whether the existing convictions should return to the Court of Appeal. The Crown Prosecution Service examined whether separate allegations involving other babies contained enough evidence for new criminal charges. On August 5, 2026, the Crown Prosecution Service gave its final answer concerning the 6 family reviews. The answer was no. For the families, that word carries a weight that cannot be captured by legal language alone. These were not simply files. They were not just possible charges on a prosecutor's desk. Each file represented a baby, a child who became dangerously unwell, a family that may have spent years asking what happened. When prosecutors first decided not to bring charges, 6 families asked them to reconsider. They wanted a second prosecutor to examine the evidence. They wanted reassurance that nothing had been missed. That second examination happened, but it did not produce a different result. The independent prosecutor concluded that the 6 attempted murder allegations still could not meet the evidential test required for prosecution. That does not provide the families with a public trial. It does not give them a jury's verdict, and it may not provide the full explanation they have been seeking. But within the criminal justice process, the decision is final. There will be no additional charges in those 6 cases. The most important lesson from this announcement is that several legal truths can exist at the same time. Lucy Letby remains convicted of murdering 7 babies and attempting to murder 7 others. She remains subject to 15 whole life orders. She continues to maintain her innocence. Her legal challenge remains under review. The public inquiry continues examining what happened inside the hospital, and prosecutors have now decided that 6 additional attempted murder allegations do not contain enough evidence to justify another trial. None of those facts cancels the others. The latest decision is neither a new conviction nor an acquittal. It is a decision about the strength of the evidence in 6 separate allegations. That careful distinction may not satisfy people who want a simple answer. But criminal cases are not decided by public anger, online debate, or the reputation of the person accused. They are decided by evidence. And when prosecutors reviewed the evidence in these 6 cases for a second time, they reached the same conclusion. The threshold for new charges had not been met. For 6 families, the process began with a challenge. They asked an independent prosecutor to look again. The files were reopened. The evidence was reconsidered. The decisions were tested. But after the review was completed, the answer remained unchanged. 6 families challenged the original decision. 6 alleged attempted murders were examined again, and prosecutors still said no.